So what exactly led to the former neonatal nurse Lucy Letby receiving 15 whole life sentences and becoming one of Britain's most prolific serial killers? In this series, with the use of court transcripts, I'll be taking you through a word-for-word account of what transpired inside Courtroom 7 at Manchester Crown Court. Now, before the jury considered their verdicts, over the course of 5 days, the presiding judge, Justice James Goss, provided the jury with a complete overview of the evidence presented by both prosecution and defence during the course of the trial's 8-month duration. The following will provide you, the viewer, with a factual look at what took place during Lucy Letby's trial and the evidence presented from both sides. The following is the trial of Lucy Letby, the judges summing up. In 2015 and 2016, there was a significant rise in the number of babies who suffered serious and unexpected collapses in the neonatal unit in the Countess of Chester Hospital. The prosecution case is that these collapses were not natural events, but were caused by the defendant Lucy Letby, using various means to harm babies, intending that they should die. Some died, others were resuscitated, or in the cases of alleged poisoning by insulin, the source was removed. A number of the babies were subjected to what the prosecution alleged were repeated attempts to kill them. After a year, it became clear that of all the nursing staff and doctors, the defendant and her alone was at work on the unit at relevant times and was sometimes present when unexpected collapses occurred. Following the deaths of Child O and Child P and the collapse of Child Q on successive days on the 23rd to 25th of June 2016, the defendant was confined to clerical work and stopped from patient nursing duties. I begin by reminding you of the background and context of the events giving rise to the offences alleged on the indictment. The Countess of Chester Hospital is and was in 2015 to 2016 a busy general hospital with a maternity unit within which was the neonatal unit, in which premature and sick babies were cared for at that time, and to which I shall refer as the unit, that's the neonatal unit. Given that we are concerned with the hospital structure and layout of the unit in 2015 to 2016 and events at that time and the prevailing situation and practices, I shall use the past tense in my summary. Even though it's still a functioning hospital, I shall refer to it in the past tense. In the Cheshire and Mersey neonatal network, which adopted the prevailing standard NHS structure in England and Wales, a three-tier system of hospitals was operated. The tertiary system, with which you are now familiar and is set out in section 1 of the agreed facts, which are in your second jury bundle. You needn't refer to it now. If you need to remind yourselves about the system, that's where it is. The Countess of Chester was a designated level 2 unit and routinely provided care for babies of 27 weeks gestation and babies that required intensive care for up to 48 hours. You have a plan in your first jury bundle, section 4 of the ground layout of the neonatal unit and some adjacent areas. It's a guide and not a scaled and wholly accurate depiction of the unit. You also have photographs and walkthrough recordings, one being close to the time of the events, and a more recent one recorded on the 3rd of October 2021, when equipment had been removed and the unit had been vacated. One room, marked on the plan as Room 1, was the ICU room and was often referred to as Nursery 1. There were 4 incubators and 2 computers in there, as well as other equipment. Nurse Melanie Taylor remembered it as shown in the walkthrough recording. Room 2 was the High Dependency Unit, the HDU, often referred to as Nursery 2. And Rooms 3 and 4, Nurseries 3 and 4, were Special Care Babies rooms. The details in relation to the rooms and the means of entry and reliability of swipe data are set out in section 3 of the agreed facts. Also in that section are the details relating to the medical staff. The very last evidence you heard in the case was from Lorenzo Mansuti, an estate plumber for the hospital since 1986. The Women and Children's building of which the unit forms part was built in the 1960s. There have been issues with the drainage system in that building, assorted and various blockages maybe once a week, he said. There was one occasion in 2015 to 2016 when he believed a hand basin in Nursery 1 in the unit backed up with foul water. He was also taken through plumbing incident reports, including one on the 26th of January 2016, when at 02:30 hours the floor of Nursery 4 was flooded because a mixer tap was switched on and a sink was blocked by waste products having been put down it. That was not on a date or around the time of any incident in the indictment. There were 9 other incidents in the Women and Children's building, not all of which were in the unit. The doctors and nurses all worked on a shift pattern. The doctors comprised the conventional grades of hospital doctor, consultants at the top, with specialist doctors in training below, identified by a T number. Registrars being next, and senior house officers in the lowest grade. The number of years registrars and senior house officers had undergone specialty training reflected their level of experience. The doctors would cover the children's ward and the neonatal unit, so would not necessarily remain within the unit for the full duration of a shift. There were 7 consultants at that time. Dr. Gibbs explained that every specialty in the NHS wanted and wants more staff. An increase had been planned for many years and was necessary because of the need to comply with the European Working Hours Directive, which was applicable at that time. This was a nationwide problem in paediatrics. Dr. Gibbs said it would have been better if more consultants were available, but he refuted the suggestion that there was any compromise of the appropriate level of care given at that time. There was a consultant of the week who covered both the paediatric ward and the neonatal unit. That style of cover was common for a district general hospital and one that they had followed for many years prior to 2015. He said they weren't complacent about whether they were offering appropriate care for babies on the unit. They carefully monitored activity on the unit, and each year they would look at the outcome measures, a crude but important one being the number of babies who died on the unit. And every year, up to 2015, the number of deaths on the unit were within the expected number for a unit of their type in the region, which was less than the national average. Yet, with those same consultants, in 2015 to 2016, the number of deaths increased significantly, with a marked difference in both the number of deaths and in the unusual and unexpected nature of the deaths. The defence contend that this was a consequence of the increased number of neonatal babies at that time and the higher acuity of those babies. As I shall remind you, as the number of such cases increased, the clinicians started to think the unthinkable, as it was described, that these were not naturally occurring sudden collapses, but the consequences of deliberate, harmful acts. Generally, there would be paediatric consultants on duty between 0900 and 1700 hours each day and one on call at night who was within 10 minutes of the hospital. I shall use the 24-hour clock at all times to avoid confusion with AM and PM, and I won't say hours each time, I will just give you the numbers. Registrars and senior house officers were always either in the paediatric wards or in the unit, and the registrars, who would have up to 11 years post-qualification experience, generally provided the senior medical cover overnight. In her evidence, the defendant was asked about her relationships with other members of staff. She confirmed that apart from Dr. B, who was very involved in the attempt to resuscitate child P, count 21, and with whom she didn't have the best working relationship, she had no problem or issue with any of the doctors and had a normal working relationship with them at the time of the events in this case. She loved Dr. A as a friend, but was not in love with him. Later, she characterised Dr. Stephen Breary, a consultant and neonatal lead at the hospital, as a bastard, after the investigations had begun. He, she said, was one of 4 consultants, the others being Dr. J-Ram, Dr. B and Dr. Gibbs, who have conspired together falsely to apportion blame on her and, she believed, to cover up the failings at the hospital. Nurses who worked at that time in the unit generally fell into one of 4 bands in the hierarchy below the ward manager, agreed Fact 12 in Section 3. Band 6 nurses were at the top, Below them were Band 5 nurses, who were split into those who had done the special training in caring for ICU babies and those who had not. Below them were Band 4 nurses, also known as nursery nurses. The nurses worked in shifts. It was the general rule that a nurse who started on a shift in the unit remained there for the whole shift. The day shift generally started at 07:30, with the preceding night shift ending half an hour later at 0800, during which time a handover would take place. Melanie Taylor, a Band 6 nurse, often referred to as Mel, was the first member of the hospital staff to give evidence. That was on the 19th of October last year. She was the first of many witnesses who gave evidence screened from others in the courtroom. She explained the handover process. I remind you of the oral direction relating to a witness being screened, which I gave you at the time and which you now have in writing. It is legal direction 1 in the second set of legal directions, and I have to read through them, although you have a copy of them, so I'll read through each of these directions as and when they are relevant. A witness giving evidence from behind a screen is permitted by law and is now commonplace, the purpose being to assist the witness to give their best evidence. It has no relevance to the quality of their evidence as a witness, and you should attach no significance whatsoever to a witness giving evidence in such a way. You judge the witness in exactly the same way as you judge any other witness. You certainly do not hold it against the defendant or her case that a witness has given their evidence in this way. And I'm sure that you wouldn't do that, and you probably can't even remember which witnesses were screened and which weren't. Certainly all of them. You'll remember some, not all of them. So attach no significance to the fact there were screens for some witnesses. Some other witnesses gave evidence over a video link, sometimes from other parts of this country or from overseas, Switzerland and Australia, you'll remember. This was purely for the convenience of those concerned and was an obvious cost and climate-saving measure. Of course, you do not attach any significance to any of them giving evidence in this way. You judge them as witnesses in the same way as you judge any other witness in the case. You've heard from a number of nurses that all nurses coming on duty would have a huddle in a separate room, which the shift leader of the previous shift would pass on general information in relation to all babies. The nurses would then go to their own designated baby or babies for a one-to-one with the designated nurse coming off shift, who would give them an in-depth handover and provide handover sheets for the babies. At the cot side of each baby there would be a clipboard with that baby's charts, such as observations and fluid charts. Those charts were completed at the time and the times were recorded on them. Caroline Bennion said observations take about 10 to 15 minutes if straightforward, and could take up to 25 minutes if care or repositioning had to take place. The time recorded for the readings and observations were taken around the time of the observations and not precise to the minute. The general nursing notes were written up on a computer retrospectively. In her evidence, the defendant confirmed that these were the procedures, and you now have become very familiar with all the various hospital documents. When making nursing notes, you did have an accurate electronic time of the time of starting to make that note and the completion of that note. Staffing levels. A number of neonatal practitioners, Nurse A, Caroline Bennion, Nurse B, Caroline Oakley, Catherine Percival Ward, now Percival Calderbank, and Belinda Williamson, then Simcock, were asked about staffing. Nurse A said there were periods when they were short-staffed and they didn't always reach the BAPM guidelines, to which I shall refer as they have been during the trial. Ideally, there should be 2 Band 6 nurses on any shift. Sometimes there were potentially more babies in the unit than there were meant to be. When a shift was a bit short of staff, a nurse might be asked to staff shift or do an extra shift, and there would be flexibility with the rota. Nurse A also said they always had a lot of senior staff who supported the junior staff, but 2015 to 2016 was a busy period, with more babies requiring a higher level of care, higher acuity, and there were times when the BAPM gold standard could not be achieved. Melanie Taylor remembered there were a lot of busy shifts around that time. Nurse B also said the unit was very busy in 2015 to 2016. Admissions seemed to increase and they had far more intensive care babies. It wasn't always possible to follow BAPM guidelines on staff ratios, but staff were giving up breaks to provide care. Caroline Oakley didn't remember the unit being unduly short-staffed. There were always a lot of babies and it was always quite busy. Catherine Percival Ward, now Percival Calderbank, said there were a lot of babies that became sick at that time and they were particularly busy. Belinda Williamson said at times it was difficult to get hold of a doctor when needed, particularly at night if the paediatric ward was busy. But in relation to nurses, she said it was rare for there not to be 2 Band 6 nurses working on any shift, as the BAPM guidelines provided. In his evidence, Dr. Stephen Breary accepted that staffing levels were lower than BAPM standards during this period when the college reviewed their care in September 2016. It was also noted in that report that this was similar to other units, and at the time when these events happened, their staffing levels were better than all the other local neonatal units in Cheshire and Merseyside at that time. Those units didn't have the same mortality problems as the Countess of Chester. A good deal of questioning by Mr. Myers and his submissions to you was directed towards staffing levels and the level of care provided by both medical staff and neonatal practitioners, and in some cases their level of experience in dealing with some of the more vulnerable neonates. There is evidence of occasions when, contrary to the standard, a nurse on a shift was the designated nurse for more than one intensive care baby. There is also evidence of occasions when nursing staff complained about particular shifts and when care was suboptimal. In other words, not as good as it should have been. The potential relevance of this evidence in this trial is whether any specific or identified failing of, or by any of the clinical or nursing practitioners, whether by way of inexperience or competence, or numbers on duty at any time, or by error, was or may have been relevant to the deterioration of any baby or to an event that you are considering. In particular, whether a failure of care or mistake may have been causative of the sudden deterioration in the condition of any of the babies in this case, or adversely affected their chances of recovery, and if so, which. For example, there was an admitted failure to give child D antibiotics after birth and a delay in giving surfactant, about which I shall remind you. In the great majority of cases of the babies in this case, the defendant herself accepted that staffing levels or negligence in their care or treatment of them played no or no causative part in their collapse and or death. I shall review all the cases for you, identifying in each of their cases the history of the baby, their condition, and the circumstances in which they variously required emergency resuscitative treatment, what was done and what was not, and the expert evidence in relation to the way that the clinicians and nursing staff treated the babies, and what the defendant said about any potential nursing or clinical mistakes. It will be for you to determine the relevance of these matters to the deteriorations, collapses, and deaths. In his address, Mr. Myers said there was plenty of suboptimal care, that the doctors at the hospital have resisted criticism, and he repeatedly suggested that they were blaming the defendant for failings in what had happened, and had gone out of their way to damage her and use it as an opportunity to cover bad treatment and poor outcomes. He submitted that the evidence in relation to alleged types of harm inflicted was inconsistent with an intention to kill, suggesting, quote, why use different ways when an earlier alleged harmful act has been successful? Why change what worked? These and other propositions he advanced are not evidence in the case. Rather, they are inferences or conclusions he invites you to draw which proceed from and are based on the defendant's position that she did nothing to harm any baby. As I've already directed you in my written directions 1, it is your determinations of who is and who is not telling you the truth and reliable, and the conclusions you draw from all the evidence that you make your decisions. I shall endeavour fairly to refer to relevant evidence, some of which will involve you having to contextualise counsel's submissions, so you must concentrate on the detail, and if you wish refer to documents, charts and notes. I'm not going to put a single document up on the screen for you to look at during the course of this summing up, because you have them all on your iPads and can look at any you consider are or may be relevant when you are deliberating on your verdicts. In the case of two of the babies, there is evidence of unprescribed insulin having been administered when it was wholly inappropriate. They are, of course, child F, count 6, the 5th of August 2015, and child L, count 15, the 9th of April 2016, each of whom was a twin in their cases. The prosecution invite you to conclude that there can be no doubt that someone intentionally added insulin to the nutritional food and the dextrose that was being given to child F and child L respectively, and the chance of there being more than one person acting in that way can be entirely discounted. Medical negligence or accidental want of care could not, they submit, on any view, have played a part in those cases. The defence, consistent with the defendant's case that she was not responsible for adding insulin to infusions for either baby, put the prosecution to proof in relation to the fact that manufactured insulin was deliberately introduced to both those babies and that it was the defendant who was responsible for that, and if you are sure that it was, that she intended to kill. They invite you to question the evidence of the taking of the samples, their handling and testing, and given the potential consequences of insulin poisoning, the lack of harm caused. I shall therefore remind you of the evidence relating to the blood sampling, testing, the results and the associated processes and other linked evidence when I come to those counts. The prosecution say that this evidence is of major significance, being incontrovertible evidence, if you accept it, that someone was deliberately and knowingly doing something that was completely contrary to normal practice and very dangerous, and which must, they allege, have been done with the intention of endangering the lives of those children. They say that this assists and informs you in relation to the cases of other children who suffered sudden and unexpected collapses, for which there was at the time no apparent medical explanation, or where, for example, infection was suspected as a possible cause, but then later excluded by the test results when they came through. The prosecution submit it is key evidence in relation to the issue of whether these collapses were natural occurrences, or rather the consequence of deliberate, malicious and wrongful acts, characterised by Mr. Johnson as sabotage, by someone intent on fatally harming the children. By reference to my legal directions relating to circumstantial evidence and coincidence, at the conclusion of his address, Mr. Johnson gave you the lists of features in relation to the various collapses of the children that the prosecution say amount to circumstances that, taken with the clinical evidence and expert medical evidence, as well as the features of messages, the retention of medical documents, and the notes that the defendants made and kept, lead you to the conclusion that these children were deliberately targeted, and one person was responsible for their sudden collapse, and in some cases, their deaths. The defendant's case is that she was a dedicated, caring, and conscientious nurse who never did anything to harm any child. Babies do collapse for no apparent reason, and there are, it is submitted, potential medical reasons for at least some of the collapses. If there was such a person intent on harming children, it was not her. Lucy Letby was born on the 4th of January 1990 in Herefordshire and was brought up in Hereford by her parents. She is now 33 and was 25 to 26 years old at the material time between June 2015 and June 2016. She went to a local sixth form college. She always wanted to work with children and picked A-level subjects to enable her to study for a degree in nursing. She studied for her 3-year nursing degree at Chester University, working at the Countess of Chester Hospital twice during her training in 2010 and 2011. In 2012, she started as a Band 5 nurse at the Countess of Chester, working predominantly in nurseries 3 and 4. Nurse A, a Band 6 neonatal practitioner who qualified in 1992, was the defendant's mentor when she was in training. They became good friends. The defendant said she always strove to go on every course she could. She in turn was a mentor to student nurses from 2012, responsible for teaching them, carrying out paperwork on the competencies that they need to achieve. In March-April 2015, having completed a 6-month course that involved a university module, assessments, assignments and a placement at Liverpool Women's Hospital, a Level 3 hospital, the defendant qualified in the specialty, enabling her to care for the sickest babies on the unit, or those requiring the most intensive care. In 2015, she and Bernadette, often referred to as Bernie Butterworth, were the only Band 5 nurses on the unit with that specialty. All Band 6 nurses had that qualification as well. So in other words, the Band 6 nurses and 2 of the Band 5 nurses with that special training, of whom she was one. I turn next to the legal direction I must give you, which relates to character. Legal direction 2. As you know, the defendant has never been in trouble with the police and has no criminal convictions, reprimands or cautions recorded against her. That is set out in Agreed Facts Section 10, Fact 59. Not having previous convictions of any kind does not, of course, provide any person on trial with a defence, but it is something which you should take into account in her favour in 2 ways. First, it may make it less likely that she would deliberately harm any babies being cared for at the hospital. Second, it is also something that you should consider in her favour when deciding her credibility. In other words, whether she was being truthful in her evidence to you about these events. It is entirely for you to decide what weight, if any, you attach to the defendant's previous character in the light of all the circumstances and the facts as you find them to be. The defendant said that over a 12-month period she cared for probably hundreds of babies and never did anything that was meant to hurt any of them. She only ever did her best to care for them. Hurting a baby was completely against everything that being a nurse is. She was there to help and to care, not to harm, she said. She always prided herself in being very competent. Christopher Booth, Chris Booth, confirmed she was very conscientious, hard-working and willing to help. Nurse A described her as highly professional and dedicated to the work she was doing. They would talk a little about babies on the ward, and it was quite usual for them to message each other. Nurse A also said that sometimes she remained friends with the parents of babies she had nursed on Facebook, and confirmed that sometimes a nurse went to the funeral of a baby who had died if that was what the parents wanted. Another nurse, Jennifer Jones-Key, said she was a good friend of the defendant at the time. She said the defendant was a capable and hard-working nurse who gave a high level of care. Arian Powell, the ward manager, described her as an exceptionally good nurse. In her evidence, the defendant said that during the period 2015 to 2016, she was predominantly allocated to intensive care babies because there were a lot of them on the unit, and because of the available skill mix of the nurses. She was newly trained and could bring her skills from the tertiary centre for other people to learn from. She had a kind of passion for that area of work, she said. She enjoyed all aspects of her work, but she particularly enjoyed the intensive care side, and staff knew she enjoyed that area. She said she never used her phone when in any of the nurseries. It's apparent from the evidence of messaging that she would message friends and colleagues, both when at work on the unit and at home. Her health over this period was generally good. She had no time off work. She did have a condition called optic neuritis, which is inflammation of the optic nerve, and it caused pain and discomfort and blurred vision at one point in 2015, and she was under the ophthalmology team at the Countess of Chester and also the Walton Centre in Liverpool, but it resolved itself. She was very flexible, living on site in accommodation at Ash House when she recorded moving out from there to the house she had bought at 41 Westbourne Road. So at the time of the events we are concerned with, she lived first at Ash House, then moved to her home in Westbourne Road, just before child L and child M were born. She was often asked to do more than the prescribed 13 shifts per month. She was particularly friendly with Nurse E, Mina Lapalainen, Dr. A, Nurse A, and Jennifer Jones-Key. Some of those people supported her after she was moved to non-clinical duties, and that was very important. She said they were the only form of support she really had. She was devastated when she was taken off clinical duties in July 2016 and being told that there was going to be testing of competencies. She had always prided herself in being very competent. It really affected her being taken away from her support system and given a non-clinical role. She registered a grievance on the 7th of September 2016 about her redeployment. It was at that time that she became aware that she was being held responsible for deaths on the unit, receiving a letter from the Royal College of Nursing. She said it was sickening, devastating, and she changed as a person. Her mental health deteriorated and she felt isolated. She was only allowed contact with Nurse E, Mina Lapalainen, and Dr. A. The latter was a close friend. She was first arrested on the 3rd of July 2018 at her home at 0600, as set out in Agreed Fact 25. She was then interviewed over 3 days before being released on bail and went to live with her parents in Hereford. Her house and that of her parents were searched, and various documents including shift handover sheets and resuscitation notes, diaries and sheets of closely written notes were found and seized, to which I shall refer in due course. She was rearrested on the 10th of June 2019, further interviewed, and further searches were conducted, and again she was released on bail. Finally, she was arrested a third time on the 10th of November 2020, interviewed and charged, and has remained in custody since then. The arrests, she said, traumatised her. She accepted that a large proportion of the prosecution papers were served on her in early 2021, though not all, and that by February 2022 she knew the important features of the allegations. A defence statement was confirmed by her on the 11th of February 2022. Some of its contents appear to be different to what she said in evidence to you. And I now refer you to the next legal direction, Legal Direction 3. Defence Statement. Just as the prosecution must disclose all of the evidence upon which they intend to rely, the defence must also serve a formal defence statement which informs the court of those parts of the prosecution case with which the defendant disagrees, and the facts upon which the defendant is to rely in their defence. This is to enable the issues to be identified for each side to prepare for the trial, so that neither is taken by surprise. In this case, the defence statement was served in February 2022. You've been provided with a copy of the relevant parts of it. The prosecution asked the defendant about things she said in that statement compared to what she was telling you in evidence. If you find there is a material difference in what she said in her defence statement and what she said in evidence to you, just as with any witness, you are entitled to ask yourselves why. The defence say that there was a vast amount of material to be considered and digested, and there have been significant delays between when the events occurred and her receipt of all the prosecution material, which made her task more difficult. It is for you to assess the reasons put forward by the defendant. If you find any inconsistencies to be without significance, or you accept that any account was or may be true, then you should ignore the differences. It's only if you are sure that there is a significant material change of account, and the reason for it is that she is not telling the truth to you about the matter, that you may take that change as providing some support for the prosecution case. But you must not convict the defendant wholly or mainly on the basis of such changes. It's always for the prosecution to make you sure of guilt. Before I turn to the evidence relating to the events, I need to give you two further legal directions which relate to delay and expert evidence. These are directions 4 and 5. Legal direction 4. Delay. There have inevitably been delays between the events giving rise to the allegations and the defendant. The taking of witness statements, her being questioned about them by the police, and then giving evidence some 7 or 8 years after the events. All witnesses, including the defendant, have been dependent on, in part, contemporaneous records and notes, and what they recalled when making statements closer to the events. Some have clear recollections of certain events by reason, they say, of their unusual and memorable nature. For all, the passage of time is likely to have affected memories about exactly what happened and the ability to recall all details of events, even with the benefit of contemporaneous records. So make appropriate allowances for that, and take account of the delay, and in particular any disadvantage caused to the defendant in relation to being able to recall with precision what took place and remembering details which may have assisted her. You know from agreed fact 57, for example, there was no swipe data for entry to the unit available for the period between the 17th of July and the 22nd of October 2015. I just point that out that that's something that is missing. There's simply no evidence because there's no swipe data, so if it's relevant, you take it into account. So that's the direction in relation to delay. Then expert witnesses. This is a long direction, as you will see, and I'll go through it with you, and you can refer to this, if you so wish, when you are deliberating in due course. Expert witnesses. Expert evidence given by someone with specialist knowledge is given in order to help you with matters which are likely to be outside your knowledge and experience. You have heard evidence from experts in the following disciplines, namely in paediatrics and neonatology, Dr. Dowie Evans and Dr. Sandy Bowen. In paediatric haematology, Professor Sally Kinsey. In paediatric radiology, Professor Owen Arthurs. In paediatric neonatology, Professor Stavros Stivros. In paediatric endocrinology, Professor Peter Hindmarsh. In forensic pathology, Dr. Andreas Marnarides. You would expect to hear evidence in a case such as this from people with an expertise in these particular areas. They provide you with evidence about medical matters that is within their own area of knowledge and expertise. Each owes a duty to the court as an expert witness of independence, and their role is to be a witness and not an advocate. Each has an expertise gained from their accumulated knowledge and research in a particular specialised area of medicine. Although you know that experts were instructed on behalf of the defence, and there were meetings between experts, the only witnesses from whom you have heard were called by the prosecution. The defence have addressed you on what they submit is the limited expertise of the prosecution witnesses, as well as the extent and reliability of the body of medical and scientific material relied on by some of them, in particular Dr. Evans and Dr. Bowen, and their approach to their role as an expert witness, including their independence and duty to act as a witness and not an investigator. I shall remind you of the limitations and criticisms relied on by the defence when I come to their evidence. You are entitled to, and no doubt will, consider the respective opinions of each expert when coming to your own conclusions about the case. However, as with any witness, it is for you to decide whether you accept some or all of the evidence of any expert witness. It's your view as to the significance and reliability of this evidence that is important. In this case, the factors that you should take into account in determining the reliability of the expert opinion include the extent and quality of the data and material upon which the expert opinion is based, the validity of the application of the evidence by the expert to the known medical criteria. In relation to part of the evidence from Professor Arthurs relating to the cases from the records of Great Ormond Street Children's Hospital, he reviewed the extent to which any opinion based on that material has been reviewed by others with relevant experience, the extent to which the expert's opinion is based on opinion forming outside the expert's own field of expertise, the completeness of the information available to the expert, and whether the expert took account of all relevant information in arriving at his or her conclusion. You should be astute to any potential flaws in an expert's opinion which detract from its reliability. For example, the extent to which it is based on a hypothesis which has not been subjected to sufficient scrutiny, including experimental or other testing, or an unjustified assumption, or relies on an inference or conclusion which has not been properly reached. The expert evidence is part of the case, and you should have regard to all the evidence, including but not confined to the expert evidence. Put another way, you do not consider expert evidence in isolation. Each expert was giving opinions purely from the viewpoint of their own specialised knowledge. Each was obliged to confine their opinions to conclusions they could draw from their own specialism. You do not consider the opinions of the individual expert witnesses in isolation. Rather, you consider them in the context of all the other evidence in the case, including other medical evidence, both expert and clinical, and any relevant circumstantial evidence, in order to determine the cumulative weight of all the evidence. The expert evidence is given, of course, by reference to the evidence of the clinicians, the doctors and nurses, and nurse practitioners of various levels of qualification and experience, and all the clinical and other data about which I shall remind you when I summarise their evidence in relation to individual children. The medical practitioners were making clinical judgments and acting on them in real time as the various events occurred. They, the clinicians, do not give expert opinion evidence as to the cause or causes of the events, though they can and did give evidence excluding possible causes as a result of observations, that's observations at the time, and the results of tests, scans and radiographs on the basis of their knowledge and experience. I hope you understand that. As I say, you can go through it again. In a sense, it's obvious, but it's important that is how you have regard to the expert evidence when you come to make decisions in this case. I shall deal, as I've said, with each baby in turn. A great deal of what I say shall be by the way of summary, because it is not controversial. It will be dense and factual, not out of insensitivity to the human situations of those involved, the very understandable emotional reaction to what's happened and the personal trauma and loss, but because you are making decisions on the facts, be they agreed or you find established by the evidence, and the conclusions you draw from admitted or proven facts. It refers back to those original written directions I gave you about not trying this case on emotion, but on evidence. I shall refer to tiles in the sequence of events and to J documents, so that if you think a particular document may be important, you may note it. But remember, my review will necessarily be selective and is not exhaustive. It is your view, I repeat, of what is important and what is not, and the conclusions you draw from all the evidence that matters. I am very conscious of the fact that you've already listened to 9 days of speeches. Those speeches were necessarily selective of and focused on parts of the evidence that each party submitted was relevant to your decision making. I shall provide a narrative of events, endeavouring to put matters in sequence and in context so that you have the evidence. And you'll have notes and you'll be able to refer to documents in relation to these events as they were proceeding in time.